So good morning. Good morning, everyone. Sorry, we are a little bit late. We had some various technical problems, but I guess they're all solved. Let's hope they're all solved. And then from now on, we have the technology on our side. So it's always good to be here with Professor Edison Christians. We are starting a new project. Oh, yeah, for those who don't know me, my name is Sergio André. I'm a professor here at the Rio de Janeiro State University. And Edison and I have been doing research and work together since 2016. We have 2 books to show as a result of our partnership so far. And earlier this year, we were just talking, and when I mean talking, usually texting, but that's talking nowadays. And then we were discussing ideas, and this topic of taxation of technical services popped up as something that we would be interesting to research further and maybe do something to understand better how technical services are treated, and then actually before that, what technical services are to a large extent. It relates to issues related to taxation of the digital economy. Even though it's not as fancy as talking about Pillar 1 and Pillar 2, it's like the industrial age of international taxation, talking about technical services. Looks like it's too 20th century to be discussed. But in the end, there are lots that can be done with a good system of withholding taxes on technical services. And maybe if we had worldwide a good system of withholding taxes on technical services, maybe the whole discussion on the digitalization of the economy would be less relevant than it is today. So this is why we are here. So we had this first book coming out in 2017 on tax sovereignty post-BEPS. Then last year, we did another book on multilateralism and implementation of the Multilateral Convention. And we've been lucky to have Kluver with us in these 2 projects. And now we're starting something new. So, and as we start something new, we decided to do it ourselves first. But the idea is that from now on, from time to time, we'll be here with other professors, other practitioners from other countries that will come and share with us their experience and their country's experience regarding this topic. And we decided to start with Brazil and Canada. This is a very hot topic in Brazil. Edison will be able to tell us if it is such a hot topic in Canada later. But Edison, before I start talking about Brazil, I'd like you to just say a few words and welcome whoever is watching us live or later on. So I give you the floor.
Thank you so much. It's always such a pleasure to see you, Sergio, as you know. I love that you push me to always keep learning. I think this is why I love doing projects with you, because sometimes, like with this topic, it is, as you say, it is not exciting to people. Oh, technical services. And in a way, it's old, right? This is an issue that's been around for several decades. But it's got renewed energy. And I think you're absolutely right that if we had actually dealt with this problem head on, and really taken it seriously, we might not be where we are today with digital services. So I'm excited to talk to you about it, but I really am viewing this particular conversation as a learning conversation, one where I'm going to learn from you. So I have some thoughts, but I think you have the better part of the expertise here. So I'm counting on you.
That's not fair. You're shifting all the responsibility for the success of
It's
our
fun being a
conversation.
student. Students don't realize
My
this.
shoulders are heavy now. I'll try to do my best. It's true that Brazil is a very interesting and intriguing jurisdiction when it comes to taxation of cross-border technical services. So yeah, to some extent, it will be great to share this with our audience. And I have to make a disclaimer before I start. This discussion regarding the taxation of cross-border services in Brazil, this is so large. There are so many aspects to it. And even though we are both, I guess, tax nerds and we love discussing tax issues and international tax issues, and we have some time because there's no one pressuring us to stop talking. There are limits to how long people would like to listen to us. So in preparing this presentation, I had to make tough choices to limit our discussion to what is actually our goal in this new endeavor, which is to discuss what is the policy regarding the taxation of technical services, and I'm saying that maybe for the benefit of the Brazilian audience, because as I said, this is such an extensive international tax issue in Brazil. And of course, it's not my goal here to review all the aspects and the specific Brazilian tax implications. This is not what we are, planning to do in this meeting. So we need to some extent present the overall picture, so that later on, when we have people from other countries, we can compare and see what is one country's policy in comparison to the others, and etc. So that's it. And to make this, I always avoid sharing presentations in these webinars, because I think that they I don't know, they distract the audience. But in this case, I'll make an exception, and I'll share a couple of slides that I prepared to guide our conversation. So here they are. I hope you can all see them. So as I said before, our goal here is to present very briefly Brazil's approach to the taxation of cross-border technical services. There is another disclaimer that I would like to make, because I won't have the time to talk about this specific issue as I would like. I am personally and academically a supporter of taxation of cross-border services at source. I have been for many years now very critical of the so-called permanent establishment principle. A couple of years ago, back in 2020, I was with Alison virtually at her university, at McGill University, discussing a world without permanent establishments. I have a huge opposition against Article 7. If it were up to me, I would just delete it from treaties. I think it's counterproductive. It is based on a criteria for allocating taxing rights that favors developed countries and developed jurisdictions. So And of course, I'm not going to talk about this because this is not the focus of my presentation. But since this has been a very important aspect of my production in the past years, I would like just to say that the fact that we are going to talk about the Brazil's actual policies, it doesn't mean that I to any extent reject what I've been saying, that of course countries should be allowed to tax services in general. I even dislike this idea of qualifying services as technical and non-technical. It creates conceptual discussions that are unproductive and moot. So ideally, we should have a rule for services with a very broad concept of what services are. Just the fact that we are talking about technical services creates difficulties. So when Article 12A came up in the UN model and dealing with technical services, I was just thinking, well, why not just an article on the taxation of services with a very broad definition of what services are. So this is, we can later put in the comments in the YouTube broadcast the link to that speech I gave at McGill back in 2020 when we were talking about a world without permanent establishments. Unfortunately, I won't have the time to talk about permanent establishments, which is another topic that I like very much. So with all these disclaimers, I'll start finally talking about Brazil's approach to the taxation of cross-border technical services. Okay, I have just a very quick slide. This is very ordinary for a Brazilian tax expert, but for the benefit of those non-Brazilian tax nerds who are with us or will be with us, I'm just here summarizing the main taxes we have in Brazil on the importation of technical services. So it starts with withholding tax of 15%. This 15% rate will be increased to 25% if the recipient is in a low tax jurisdiction. So if the recipient is located in a blacklisted jurisdiction, and Brazil works with a blacklist, this withholding rate would be increased to 25. So if you're paying to Germany, it's 15. If you're paying to Cayman Islands, it's 25%. And in this case here, we have a withholding tax. In principle, even though it's pretty common that these taxes will be grossed up and the actual burden will lie with the Brazilian resident contracting the service, in principle, this is a withholding tax. It should be withheld from the payment to the non-resident. It's funny because when we follow up all these discussions about DSTs and all the controversies and etc., since 2021, and it became effective in 2022, we have this social contribution on the importation. So it was enacted in the year 2000, and at first it was levied only royalties and transfer of technology. And then in 2001, it was enlarged to also include the importation of technical service, administrative services, technical assistance services. And it's a 10% contribution on anyone who is contracting any of this. So if you're paying royalties, you have to pay 10%. If you're paying technical service, you have to pay 10%. And it's levied on the Brazilian resident. So of course, there's not as many discussions as we saw with the DSTs, because with the DSTs, Countries like France, Italy, Spain were trying to tax directly the big tech companies in the US, but here it works pretty much the same. But the only thing is that instead of taxing the non-resident, you're taxing your resident. So you're creating an economic double taxation. In principle, it falls outside the scope of tax treaties. We're talking about a 10% contribution. It's not 3%, it's 10% contribution that anyone, there's a constitutional debate regarding whether or not this contribution is constitutional. It's been around for 20 years, but apparently this year, 2022, the Supreme Court is going to analyze this again. So maybe we have some news in the near future, but the fact is that in the last 20 years, we have had this 10% contribution on the importation of technical services. In addition to that, we have these two contributions, PIS and COFINS, and they are social contributions on imports of goods and imports of services. So they have a joint rate of 9.25%, and they are also levied on the importer of the technical service. So if you are importing a service, you have to withhold the 15%. If you're lucky, if you're unlucky, you will have to gross that up, which will lead you to 17.65% of tax cost, of withholding tax cost. In addition to that, you have the 10%. And in addition to that, you have the 9.25%, which might be creditable in some cases. So it could be creditable depending on what you're paying for. But that's the cost. And of course, these are all federal taxes. So these taxes are levied by the federal union. But in addition to that, you have the municipal service tax, which rates vary from 2% to 5%. So in large capitals like Rio and Sao Paulo, usually it's usually 5%. So in addition to all the federal taxes, you also have the service tax. Calculations of how much this cost varies from taxpayer to taxpayer, because we also have large discussions on the taxable basis of each one of these taxes, so on how you calculate. But with the gross up, we're talking about a burden that is somewhere around 50% on the price of the service. And I remember a couple of years ago, I was reviewing a PhD dissertation at the University of Sao Paulo, a PhD thesis, and I had João Félix Nogueira from the IBFT here in Brazil. And he said he was touring around to make the case for DSTs. And I remember telling him, you know, man, we have a 50% tax on this. You know, if you are arguing that we should replace this for a 3% DST, you know, I really don't think that you're going to find open ears in Brazil. Just, yeah, let's do this. Let's revoke all these taxes. And then we'll have this 3% DST that we'll have to collect from the non-resident. So basically, you depend on, you know, their good intentions and they're coming over here and paying the tax. While Brazil has established a system that's pretty much focused on their Brazilian residents. So they don't need any big tax to feel like paying taxes in Brazil because they're levying the taxes on the Brazilian residents. So this is just a very brief summary. Lots of complexities in all these taxes, but it's a big summary, as I said, for the benefit of non-Brazilian tax experts. And then we move on to something that maybe is the focus of our debate here, or the main focus of our debate. What are technical services? Because it's interesting, because technical services as an expression has been used for decades in Brazil's domestic withholding tax regulations. So they make reference, explicit reference to technical service, administrative support services, technical assistance services. But the matter of fact is that we have no legal definition of what technical services are. So there's no indication in the law of what technical services are. And that's the problem with using this adjective of technical. Actually, in Brazil for decades, we have had tough discussions regarding what services are. And then just to make things easier, you say, no, this is not just services, these are technical services. Since 2002, we have had a definition of technical services and normative instructions, which are acts enacted by the tax administration. So it's basically a definition by the tax administration. So it's not based in law, it's their approach to what a technical service is. And the first definition of technical service came in a normative instruction that was issued back in 2002. And basically, it established that a technical service is a service that requires technical knowledge to be executed, which is a very broad service, a very broad definition, because in principle, if you're importing something, if you're contracting something outside of Brazil, you would assume that it requires some sort of technical knowledge. Otherwise, you would probably retain the service here. So it's a really very broad definition. In 2014, this definition was changed. And then they included in the concept of technical service, for instance, administrative support services, and so administrative assistance services, and also technical assistance services. And why did they do that? Because from a domestic perspective, all these services, they are subject to the same federal taxation. So in principle, they were doing that because from a domestic taxation perspective, it doesn't make much difference. But the problem is when you start trying to interpret tax treaties, considering this definition, which was not meant to apply in the treaty realm. So, and this is something very important. The only definition we have in Brazil's domestic regulations is in this normative instruction. And it was made because of, it was created because of this CID-DE contribution. Because if you have a technical service, a technical assistant, administrative assistance service, or a technical assistance service, you have 15% withholding tax and you have a 10% CID-DE contribution. But if your service does not fall in any of these three categories, then you have a 25% withholding with no contribution. So that's why it's important to establish what is one thing and what is outside of this group. Because if you are inside this group, technical service, technical assistance service, or administrative assistance service, you have a 15% withholding plus 10% CID, 25% withholding if the payment is to a low tax jurisdiction. On the other hand, if your service doesn't fall in any of these three, you have a 25% withholding with no CID. That's why domestic regulations is starting trying to define what is one thing and what are the others, and even though we can't say that this is very clear. There's just one thing that I would like to highlight from this definition. Back in 2014, when this definition came into play, there was the end of the definition that said that it's also a technical service, anything resulting from automated structures with technological content. Maybe I'm going too far, but I would dare saying that Brazil invented Article 12B of the UN model back in 2014. So we were all having these heated discussions and about whether or not we should have, but in the Brazil's domestic regulations, this has been included in the concept of technical service since 2014. Again, whether or not this is applicable when we're looking at interpreting and applying tax treaties, it's a different discussion. But and it's interesting because I remember when the normative instruction was enacted back in 2014, and there was this big question mark in everybody's minds. What the hell is this? What are they trying to do with this? Because even though it's yesterday, 2014, the world was different, 8 years ago than it is today. So it's this is the domestic definition of technical services that we have. Then that's now delve into our main subject, so technical services and treaties. Brazil's approach to the taxation of technical services in our treaties have changed in time. It's very interesting that our first treaty to come into force was the treaty with Japan, which became effective in 1967. It was our first treaty. And then in the 70s and 80s, we signed lots of treaties, considering the size of our treaty network, which is currently 35 treaties in force. And it's very interesting that technical services had been a known issue until the late 1990s. There was this international tax scholar in Brazil. Actually, he was the founder of Brazil's International Tax Academy, who was Professor Alberto Xavier. He was a Portuguese guy who moved to Brazil in 1965. And in 1977, he published the first edition of his textbook on Brazil's international taxation. So he basically founded Brazil's international taxation. And I've been saying something with all the respect because I'm a fan of Professor Alberto Xavier, or Xavier in English too. I'm a huge fan of him. But, and I've been saying this, he passed away back in 2016. But he kept Brazil's approach, or Brazil's experts' approach to international taxation, OECD centric, because he was the guy. So he was the one. He was the professors of all the professor of all the professors. He basically created it, and he was an European scholar to the end of his days. So, and his approach to what a Brazilian international taxation system should be was totally OECD centric. So I've been saying that only now we've been starting to actually find our steps and to create a real Brazilian international tax approach. But it's funny because only in the late 1990s, he came up with the idea that, look, we shouldn't have any tax withholding on payments of technical services because they should all fall in Article 7.1. And then, unless the non-resident has a permanent establishment in Brazil, Brazil shouldn't be able to tax that. So he came up with a thesis in the 5th edition of his book. It's fun. I have all the editions, and once I was trying to, when did he come up with this? And then I found out that he came up with this in the 5th edition of his book. And then it became a topic here, and multinationals began to ask the tax administration, should I have to withhold taxes when I have a treaty? Should an Article 7.1 apply and I don't have a permanent establishment, hence I shouldn't pay any taxes in Brazil? And surprisingly enough, the first rulings from the tax administration said, yeah, you shouldn't pay any withholding tax here. Article 7.1 applies. And look, we're talking about the 1990s. It was like 1998. I have 22 years. I was 22 years old. And basically, I was coming out of, law school and had no idea whether I would be a taxman or not. So it's a long time ago. And basically, we had 2 or 3 books on international taxation in Brazil, if there were that many. And so the tax authority, said, yeah, you're right. There shouldn't be any withholding. Of course, other taxpayers started asking the same question, and different answers started to pop up and said, no, you have to pay the taxes. Article 7.1 does not apply. And then it was at the beginning of, I guess it's January or February of 2000, the tax authorities tried to come up with a unified interpretation. And they said, you have to pay taxes in Brazil because the other income provision applies in the treaties. And this was probably the most controversial international tax interpretation from the Brazilian authorities ever. And it created a kind of mythology that Brazil does not abide by treaties because it said that services characterized that other income, and this was absurd and outrageous, and etc. And for a long time, I said those things as well when I was a colonized Brazilian, expert. But nowadays, I totally understand what happened. I don't agree. And the fact that you don't agree doesn't mean that the other side is manipulative. So what happened was that why did Brazil at that point said that technical services qualified as other income? And first, we need to understand that the other income provision in Brazil's treaties allows Brazil to tax at source. So the other income article in Brazil's tax treaty practice allows taxation at source. And why did Brazilian authorities did that? And this is something that will come up later in my presentation. When you look at Article 7, the business profits expression, we don't have a definition of business profits in the treaty. So what did Brazilian authorities do back then? They said, this provision is about profits. There is no definition of profits in the treaty. So I will apply my local legislation definition of profits, which is a corporate law definition. And according to our corporate law or the corporate income tax regulations, a profit is the outcome of, income minus expenses. And then you have a profit. You have revenues, you take out the expenses, and you have a profit. And they said, yeah, if you're paying for a service, this is a service revenue. This is not a service profit, because only at the residency country we will be able to calculate what the profit is. Then, if this is not a profit, I cannot apply Article 7. And if Article 7 does not apply, I have to apply the other income provision. So that's how Brazilian authorities manage to formally establish that they would apply the other income article. We can all disagree with that. But we need to remember, we're talking about Brazil in the year 2000. Again, we have free books. We have no actual knowledge, no actual experience. International taxation was a non-topic back then. And you have these authorities trying to interpret the regulations and the treaties with what they had at hand at that time. The only thing in this particular act that was funny is because the first rulings, they were related to the interpretation of the Brazil-France Treaty. And the Brazil-France Treaty, for any reason, doesn't have the other income provision. And then they included a sentence saying that the other income provision would apply even if the treaty doesn't have one. And that was really creative. That's really out of the box thinking. I don't know certainly someone had this great idea, and they were discussing the tax. So I know how to deal with this. Just say there that we're going to apply even if the treaty doesn't have the provision. Let's do it. Why not? We have the pen. We do whatever we want. Okay, so from 2000 to 2013, that was the official Brazilian position, even though in practice there were divergent rulings and interpretations, but this was the official Brazilian position. In 2013, something happened. The IC country of Finland decided to send a communication to Brazil saying, look, I don't agree with the opposition. And if you don't change it, I'm going to denounce our convention. You cannot move on withholding taxes at source on payments to Finnish residents. And there is another issue here. I'm going to talk about this later. And in 2012, the administration had lost the first case about this topic in a higher court. So they had just lost the case, and they had the Finland pressuring for them to change, and then they changed. And it was December 2013, and Brazil said, yeah, Finland is right. And this is very interesting what they said here, because they said we should not interpret the term profits in accordance with our domestic regulations. And then they went to the OECD commentaries, and they got the definition of profits in the OECD commentaries. And they said, yeah, this is the international definition of profits. And this is what we should consider in this case here. And this is the tax administration saying that, yeah, we should use this international definition of profits, not the definition of profits in domestic regulations. But then, and it was funny because people in Brazil who were not actually tax experts were celebrating, saying, yeah, Brazilian authorities agreed with the taxpayers' position. And as a matter of fact, they did not. What they did here was that they changed their main argument, because so far their official argument was technical services are other income, and they were facing all the criticism for saying that and etc. But here they changed, and they said, yeah, let's look at our treaties. And there's a lot of simplification here because the provisions are not the same, but we can look at Brazil's 35 treaties and find 3 different types of treaties. We have 5 treaties in which you don't have any provision regarding the taxation of technical services. These are the treaties with Austria, Finland, France, Japan, and Sweden. Brazil is currently renegotiating his treaties because we didn't sign the MLI, and we had this commitment of renegotiating everything. And of course, we are including provisions regarding the taxation of technical services in these treaties. We already have a new protocol with Sweden in which technical services, so these treaties will probably move at some point in time to type 2, which are treaties in which technical services are included in Article 12 and are taxed as royalties. So this is what they did in the new protocol in the treaty with Sweden, which is not in force yet, but it has already been signed. So we have these 5 treaties with no provisions. They will probably all have one in the near future, or not so near because it takes time to renegotiate then for Congress approval, etc. But at some point in time, they will most likely all have provisions which will look like a type 2 treaty, which are treaties in which you explicitly have in the protocol a provision establishing that technical services are included in the definition of royalties. As I said, there is some simplification here because the wording in these treaties are not the same. It's not the same. So you have different wordings, but in the end, the core thing is they all establish that technical services should be treated as royalties. And then the question, but what are technical services? And we have this type 3 treaty, which are our post-BAPs, our most recent treaties. They already have PPT clauses and all the post-BAP stuff. And they also started to include, these are post-2017 treaties, they also started to include a Article 12A from the UN model. So they started to include the technical services provision. So now we have these 3 types of treaties. But look, with exception to those 5, it's clear that Brazil is always looking for taxing technical services at source. So what was the tax authority's position as from 2013? They said, yeah, if you have a service, if it is a technical service, you must look at the protocol, and if you have a provision saying that it's a royalty, you should tax it in accordance with Article 12. It's royalty. If it's not a royalty, if it's not a technical service, then you have to look at Article 14, because all of our treaties have Article 14, which maybe from a developed country perspective is no longer a big topic, but here it still is. In our Article 14, usually grant larger taxing rights to the source country than the UN model does. Because in many treaties, it's enough that you're paying from Brazil for Article 14 to apply. So what they said in 2013 was, yeah, you look at first if the protocol applies, and then it's a royalty. If it's not a royalty, then you look at Article 14, because it might be an independent personal service. If it's neither of them, then you go to Article 7.1. And if you don't have a permanent establishment, you don't have a taxation at source in Brazil. So this is Brazil's official position today. First, whether or not this is a royalty, then whether or not it's an independent personal service, and then only then you will apply Article 7.1, then it will be business profit. And of course, just it's important to highlight this. I'm talking about technical services. If it's a non-technical service, the tax authorities, they themselves, they recognize that you move directly to Article 7.1. If it is a administrative assistance service, you would move directly to 7.1. We're talking about technical services, which is our focus here. Okay, and then our question. So, what are technical services in Brazil's treaties? We have only one case in which you have a definition of technical services. This is a new protocol with Argentina, which was negotiated in 2016 and became effective in 2018. And I don't know why Brazilian authorities managed to include in that treaty the same definition we have in the normative instruction. So the definition that we talked about earlier is included in the treaty signed between Brazil and Argentina. That's nice. When I saw that, I thought for a moment, yeah, so they are going to do this with all the treaties and the discussion. So, and I was giving a course to the tax administration at that time, and one of the attendees of the course was engaged in this negotiation. Said, "No, this is going to happen only with Argentina." Yeah. So, okay. And in fact, so far, Argentina is the only case. We have the treaties with the Article 12A from the UN model. We have the definition of technical services that came with the UN model. So they are treaties with definitions of technical services. And we have all the others with no definition of what a technical service is. I'm not taking account of my time here. Maybe I'm, talking for too long. I promise I'll try to move faster from now on. And here, Alison, these are questions that I'm going to raise, and then I would very much like to hear your inputs on this. Because the first thing here is the application of Article 3, Paragraph 2. So we have this term, technical services, which is not defined in the treaty. According to Article 3.2, I would then move on to, and of course, I don't want to get into all the debates regarding what is context in Article 3.2. I have my position is maybe more conservative than others, because I think that context should be interpreted in line with what Article 31 of the Vienna Convention establishes. So context are documents, are treaties, are countries' positions, for me, this is context. But I understand that maybe the prevailing position on what context is that no, it's the interpretation considering international sources, because the average international tax expert fears, using domestic law definitions, more than, coronavirus or the monkey smallpox. I don't know, it's the new one. So the first thing here is how Article 3.2 comes into play in this discussion. I noted earlier that when it came to the definition of business profits, the tax administration used what was an international definition. So the position we took in 2013 was to depart from a domestic definition and move in the direction of an international definition of what profits are. Could we do the same here? Move in the direction of, so there are more intriguing questions, because then is there a domestic definition? Because as I was saying before, we don't really have any law establishing what a technical services. We have that definition in the normative instruction, which was not meant to, guide the interpretation of international treaties. It was focused on the relation between the withholding tax and the CIDE contribution. There is an underlying question, which is, do we even have a domestic definition of, and more, here we have all that discussion regarding static or ambulatory, application of domestic definitions, because many of our treaties were signed before the first definition of technical services came into existence in 2002. So this is a huge problem, and it's funny because most people in Brazil treat this whole discussion as something very trivial. And I've been saying this is nothing, there's nothing trivial in this. This is a very I think that because many of them are just not international tax experts, they tend to simplify the discussion, but this discussion is really, really complex. And if we get to the point and we say, yeah, no, we have to apply an international definition of technical service. We have to apply an international definition of technical service. Then, and this is something that I really want our project to, clarify to some extent. Is there an international definition of what a technical service is? I was discussing this topic in a practical situation last month with a tax expert from the Netherlands. And I wanted to apply Brazil-Netherlands treaty and saying, yeah, this is a technical service. The Netherlands should accept it. And the person on the other side was saying, yeah, we have no experience with this, because this is not really a topic here. We don't have many treaties with this provision, so I have never discussed this with the authorities. And the person who was a partner in a very well-regarded law firm, international law firm, said, yeah, I have never discussed this, and I've talked to my partners. No one has ever discussed this with Dutch authorities. I wouldn't be able to say if they would accept that. So this is an interesting question. So is there an international concept of a technical service? Because in the discussion regarding the concept of profits, we had a definition in the commentaries. I don't think the commentaries would be that helpful in this case here. Maybe, and this is another question, now the commentaries of the UN model with Article 12A. And then the question, and here we get into parallel treaties discussions and things like that, which is, what's the relevance? Because now we have a few treaties in force that include a definition of technical service. But there are different treaties, they have the technical services provision, etc. Could this play a role in the discussion regarding what a technical service is? The work of the UN that resulted in Article 12A and everything regarding Article 12A could be used as international reference of what an international technical service is. So these are tough questions for us to consider. But it's funny because they were all ignored. And why they were all ignored? Because Alberto Xavier, the creator of Brazil's international taxation, his thesis was not focused on determining whether or not there was a technical service. His main argument was that if the protocol is establishing that a technical service will be treated as a royalty, this provision can only apply if it is related to a royalty payment. So his theory was not that we need to understand what is a technical service and what is not a technical service. What he said was, it doesn't matter if it is a technical service. If it's not connected to a transfer of technology, it's not equivalent to a royalty. This was his theory, and this was the discussion in Brazil, and to a large extent, it still is. So when you look at the experts talking about this, they're not discussing whether or not a particular service is a technical service. They are arguing that there's no transfer of technology. And because there's no transfer of technology, even if it is a technical service, it shouldn't be treated, it couldn't be treated as a royalty. But this is, something that Xavier created. It's not anywhere. Of course, the courts might agree with this position. I have argued this in papers in the past. So it's a interpretation. Yeah, it is an interpretation, but that's all it is. Interpretation for a well-regarded scholar. So you don't have any concrete regulations or anything like that to support this. And I promise I'm moving to the end, because this is the largest international tax case in Brazil. It's been going on for 2 decades now. It is relevant, it impacts many companies, and we have a few court discussions, court cases about this. All these cases are from the Superior Court of Justice, which should be the highest court interpreting tax treaties. I said should be because more often than not, people try to take these cases to the Supreme Court, and it's not unusual that the Supreme Court accepts to review these cases, even though it shouldn't. But the Supreme Court does what the Supreme Court wants to do. But the Superior Court of Justice should be the highest court ruling on these cases. And what's the problem here? The problem is that the first cases that got to the court, they were cases discussing the first formal position of the authorities, that this was other income. So, and then taxpayers started winning those cases with the court saying, yeah, this is not other income. You cannot use the domestic definition of profits. So it doesn't matter if it's just a payment for a service, it is business profit. So Article 7 applies. But the tax administration's arguments in this case here were the old arguments. So we had a trend, very clear trend of a favorable court final decision for the taxpayers, because the court was ruling the initial cases on this. Then after 2014, the tax administration went on a kind of, they were despaired, because they just wanted to show to the authorities that now they had a different, to the court, that now they had a different argument. So they wanted the court to start reanalyzing cases, forgetting past decisions, and now looking at their new argument. To some extent, they've been successful in this endeavor. The regional court in São Paulo, which is the Third Circuit regional court, issued a few decisions favorable to the tax authorities, applying the provision in the protocol that says that a technical service should be treated as a royalty. We had a few cases in the Superior Court of Justice in which the court said, because these higher courts, they don't review the proof in the case. So their courts meant to just interpret the regulations. So what they said in these cases was, it's not my role here to conclude whether this is a royalty, a technical service, an independent assistance, independent personal service. I would have to review the contracts and everything to conclude what it is. It's not my role to decide what it is. You tell me what it is, and based on what you tell me that it is, then I will decide whether or not you apply the treaty correctly. So this is a mess. And what is more interesting is that after 20 years, if we look at these precedents, they give us very little help in understanding what a technical service is in Brazil's treaties. And of course, it is a consequence of the change in the arguments, in the change in the interpretation. But this is still an open discussion. Who knows what's going to happen in the future? And that's why in a March morning in Brazil, we were taxing, and then the technical services topic became part of our conversations. And I think, and that previous slide of mine, I think, proves that there are many theoretical discussions which have not even been posed in the debate here. And I hope that, I think this is my last slide. Yeah, so it's already here. So I really hope that, what we are starting here and trying to do will bring clarity. And even though we're talking about Brazil, I know that this is a big topic in many developing countries and emerging economies. And also, maybe at some point we will be able to establish this connection between this debate and the whole digital economy taxation conundrum. So that was it. I'll stop sharing. I don't know how long I've been talking here.
Exactly the right amount of time.
That's a huge amount of time.
No, exactly the right amount. Exactly the right amount of time.
Yeah. If you say so. Yeah.
Well,
but that was it.
So let me react to this by saying this. I'm really glad that we decided to do this discussion, because I had a vague understanding about technical services before, and preparing for this discussion forced me to dig into some of the language, and I found myself a lot of the time saying, I don't understand how we got to where we are on this. And you just filled in a lot of the gaps, I think, for me, in just understanding the conceptual development of this idea. So I think the direction that I go in when I'm trying to get my hands around a complex area is I just try to nail down the fundamentals first. And then immediately I want to know, well, how did we get these fundamentals? Where did they come from? So this idea that Alberto Xavier is responsible for everything we think about technical services is really fascinating. So I think what I'll do is show a couple of slides or a couple illustrations by way of thinking through what you just said. And I think the key for us, Sergio, in this project is going to be this nailing down this question of, well, what do we mean by technical services? And then for me, the second piece of that puzzle is, well, when is the payment for services? And when is it for something else? That we see that thematically in the law and in the treaties, and just trying to understand what pressures are at play. Because I think you and I would agree, this is a struggle. This is like a tug of war between source and residence countries. And whatever's happening, I mean, it does not surprise me even a little bit that Brazil wrote essentially 12B into 2014. That does not surprise me at all, because Brazil is often in that place, like way ahead of the crowd, talking about source taxation, maybe beside India in terms of like pushing for source-based taxation, and the rest of the world sort of, either ignoring it or telling Brazil to stop doing that and, do something else. It's just so like a constant theme. So, well, let's just see the view from Canada. And I mean, I should caveat what I'm saying by saying I am not convinced that we think deeply enough about what this topic is. I'm not sure that we think deeply enough about it, because for me, it looks really confusing. So I want to go back to that fundamental. What's this basic problem that we're trying to solve? Well, that it's whether the payment is for a royalty or is it for a service, or are they is one the other? Is the service the royalty? Like, what the heck's a royalty? Okay, so I sort of understand the basic concept here is that when we're trying to separate the threads, we're trying to make a distinction between when you pay somebody to use like IP, copyright, patent, trademark, and so on, and in some respect, equipment, and when we're paying for somebody to give us information or know-how or knowledge that's used in different ways. Okay, if that's true, that we're trying to distinguish these two, then what we know is that there's these four kinds of things we call these things. And usually when the fee is for use, there's no problem calling it a royalty. So if you pay somebody to use a copyright or patent or trademark, nobody's like, oh, are you sure you're paying for a royalty? They sort of, yeah, you're paying for the right to use or the use of somebody's intellectual property. And where you get in trouble is when you're not sure if you're paying for the thing, the right to use something, and then you start looking, well, is it an independent personal service? Is it business profits? And then that third, which is a little weird, but it's still there. There's possibility that it could be an17employee being paid to provide the knowledge. And then what should you do in that case? Because it's not an independent person, like an entrepreneur, and it's not a business. It's just an employee, but they don't actually own the underlying asset. The business does. So there's some confusion there in the categories. So far, these categories, we like to, as you see, I put them in boxes, but we like to put things in boxes because otherwise we get stuck in the concepts and can't figure out what to do. So, all right, well, we know that the reason that we care for lots of reasons, but one of the reasons, big reasons we care about this idea is that typically a fee for use, like a royalty, is we're going to tax that on a gross basis, but we're going to give net treatment. We're going to allow offset for expenses like you talked about. So that idea of profits is really at work here. And of course, the missing thing on my side is like, well, or none of the above. And that would be the best thing for the taxpayer, is to not be a royalty and also not meet thresholds. So you don't have to get taxed at the service basis. So you'd rather have like zero be the tax base, but as between gross and net, you'd rather have net be the tax base than gross. Okay, more generally speaking. And then, okay, we know this is just in my own mind to solidify and to make sure we understand what we're talking about here, is that when you have a fee for use, it's going to be withholding. It's usually going to be imposed on the person that's paying for the right to use. And you described that multi-level system where Brazil just like hammers you when you pay for things. It's pretty impressive range of ways to grab money from the taxpayer. But when it's a fee for service and it's a net, then we know that we usually let the taxpayer file, right? Because they have to tell us what the profit and the loss is, or the revenue and the expenses. And then, but when it's an employee, we go back to this withhold, but also file system. So you withhold up front, but then the employee maybe files a return to say, well, but I also had like some employee expenses, or I'm allowed to have a basic amount or something, there might be some filing. So just structurally, there's some difference in how we think about royalties versus services, or licenses versus services, this kind of thing. Okay, and then the last thing then is this idea of like, well, what's the threshold? And the issue, I think, that makes me constantly come back to say, wow, this really is kind of a big and important topic, is that the threshold for taxing a royalty is nothing. No threshold. You tax the first dollar. There's no presence. There's no time. Let me get out of the way of that last little chevron on my slide. But usually you have some sort of presence, time, fixed base, or some kind of, trade or business rule or permanent establishment rule. Like you have all these thresholds for services. And why traditionally did we have those thresholds? Well, because the fee for service is usually paid for by the person being paid for the service. And if they're not our taxpayer, we need that nexus. But the withholding fee for use is usually paid by the one paying for the service, and they are our taxpayer. So we don't need a threshold. They're already in our net. So that's the traditional view. And what we know is that this is all sort of, getting messed up because of technology. Okay, so this just royalty or service, not technical services yet, just royalty or service already gives us this problem. Okay, if that's correct, if so far I'm okay, then I think it's worth looking at our own view on that split. And then here's the thing. So when we look at non-residents, we have two parts of our Income Tax Act that tax the non-resident. One is right at the beginning, and it says if you're employed in Canada, or you carry on a business, or you dispose, that's the taxable Canadian property, that's the capital gain idea. If you dispose of an asset property, then you're going to have this net tax. And then we have this withholding tax over further down. It's in Part 13 of our Act. And that's this 25% flat tax on royalties. And again, you just follow the standards, net basis on the taxable income. You see, because it's taxable income, and income is the net concept, just like you were talking about. But the gross basis tax on royalties is there on the theory that you don't have expenses, or we just aren't going to give them to you. In some cases, you can get some deduction if you file, and you can get some deductions. But generally speaking, it's withhold and in gross basis. And we have this rule obliging payers to withhold, and then imposing the tax on them if they don't withhold, right? And we have that for employees. As employment as well. So if you employ someone, you have to withhold, and you have to pay it if you don't withhold, and it makes people want to withhold. Okay. So then the question is, well, what do we say is a royalty? So this royalty term is, you might be surprised. I was surprised when I dug into this, that it's very expensively defined. And I wonder if this looks like your statute. So we have the payments for know-how. So the basic statute says every non-resident person has to pay 25% on any amount that a person resident in Canada pays or credit to them as. And then we have a bunch of things. And one of the things is rent, royalty, or similar payment. And then royalty includes a bunch of language. And one of the first part is that fee for use language that you see everywhere, like copyright, patent, trademark, all that stuff is there. But the one I'm focusing on now, it's starting to get closer to technical services. Royalty includes this language that you see everywhere, right? Information concerning industrial, commercial, scientific experience. Okay, so this information for experience thing, which could be interpreted by some as technical service, could be. Isn't, and that's maybe what led to the UN to start trying to hive that off into a separate provision, because people didn't agree whether information for experience equals technical service or not, and whether it should be included in royalty or not. Okay, so this is what we in Canada, we call that know-how. You just see the term sort of used when people describe this. Okay, and the technical service or the know-how, the information is going to be dependent on the use, the benefit to be derived from, the production or sales of goods or services or profits. Okay, so this language, you're going to see these three, the ABC is going to stay the same, and we're going to just change that subparagraph 2 for 3 in a minute, and we'll see some more. But here's the thing. This is the language. This language is in the OECD model, the UN model, the US models, treaties, right? This knowledge, information for experience language. And so the question is, well, do we read experience to mean that we tax technical services as royalties or not? And normally, if this was the only provision we had, I would launch into a very convincing argument, say, yeah, we do, definitely. It says information for experience, like that sounds like a service for knowledge. And we call it know-how, which sounds like technical, like you have to have technical experience. But we, like you said about context, we have to read our act as a whole, right? It has to make sense as a whole. And we have another provision, so we have to think about the next subparagraph, and the existence of the next subparagraph makes me doubt that we would automatically see information for experience as a technical service. So what's the next paragraph? Okay, I know this is heavily technical, but this is, I think, going to get to the question. So again, rent, royalty, or similar payment. And now here's subparagraph 3. For services of an industrial, commercial, or scientific character performed by the non-resident, and then where the total amount is dependent on these 3 things again: use, production, and profits. Okay. So we have this looks like technical services. It doesn't say the word technical, but it says industrial, commercial, and scientific character. So then compare that to the UN 12A, which says technical services is a service of a managerial, technical, or consultancy nature. And this idea that you need to have specialized knowledge, where technical means specialized knowledge. So Sergio, you showed that in your law, talking about specialized knowledge. So I don't know how to read my own statute. I don't know what industrial, commercial, or scientific character means. I don't know if that means technical. It seems like it does. Specialized knowledge, it seems like it does, but it's not exactly the same. So, we have to do some interpretation. Okay, so I put the rule structure for Canada together like this. Basically, we have a statutory withholding rate, 25%, and it applies to know-how in that first subparagraph, and it applies to these ICS, industrial, commercial, scientific services, in that subparagraph 3, 212(1)(d)(3). Okay. And if we get a treaty, it's going to reduce the statutory rate. And the question is the treaty going to kick one or both of those things out, the know-how or the ICS services, by way of the royalty definition? So it's in the royalty definition because none of Canada's treaties have a standalone 12A. So we're all in section 12. Okay, so if it gets kicked out of the royalty definition, then yes, of course, it goes over to business profits with a PE threshold, and it should go over to independent personal services as well, but we're going to see in a minute why I'm not sure about that. Okay, so commentary that you go and read will tell you Canada's treaties don't usually kick the services out. So they'll say, so this article from 99 says, consideration for the provision of know-how likely is deemed to be subject to this Part 13, what I just showed you, even if not a royalty on general principles. So we can't just define services. We have to think about what is a royalty if we're going to try to understand what the general principles here. And this Neil Armstrong went on to say, if the applicable treaty does not include know-how in the royalty definition, then no withholding without a PE. Standard, I think, standard interpretation. And that, but the thing is, the treaty definitions of royalty typically include the know-how language, according to Neil Armstrong. And he says, therefore, generally not exempted from the Part 13 tax. So his view is, the Canadian view is, the royalty definition most of the time includes the know-how provision, which is that first provision. And then if so, then it's not exempted from Part 13 tax. It's just reduced to the treaty rate. Okay. I know this is a lot of technical stuff, but here's the thing. This is 1999, so that's a while ago. But then again, treaties don't move very fast. So what are we actually looking at? I think this is our Canada's rule structure. So we say a fee for use or service, if defined, right, as a know-how or an ICS, industrial commercial, or what was the other, the scientific, right? Then it's a royalty. We get gross basis, 25% withholding with no threshold. So a fee for use or a service is a royalty in our rule layout idea. And there's an unless. There's no threshold unless if you are carrying on a business or you have a PE, then all that other stuff from the treaty lays itself out. So it's going to be this royalty gross basis 25% unless, and then the unless is, but the priority rule is that if you're carrying on a business or you have a PE, then you're either independent personal services or your business profits. And then the question is just, are these altered by the treaty? Okay, so this is our basic fundamental idea. We have the two categories and they overlap. Fee for use or service includes fee for service. So we kick service out by saying, but you go over to, so what we're saying is we're taxing you. We are taxing you. If you have a PE or carrying on a business, then you can have net taxation. And if you don't do those things, then we're doing royalty taxation. So you can imagine that Canada's view is get yourself a PE or carry on a business, have established a fixed base here because you want net taxation. You don't want gross basis taxation unless you can get a nice low rate under treaty, for example, 5% or maybe even less, right? So, but we want to tax it. It seems like that seems to be the structure from the law, the way the law is written, and from the commentary. Okay, I won't take too much time, but look at the UN model. Okay, where royalty means a payment for the use or right to use a copyright, patent, etc. The use or right to use this ICS equipment, and then the information concerning experience language. Okay, so that means that they have 4 categories: the fee for use, which goes down the royalty road, the fee for service, which goes down the Article 12A technical service fee route, and then and that only applies if there's no PE or fixed base, but if there is a PE or fixed base, then we're back to the Article 14, Article 7, independent personal services, business profits. So that fee for service is duplicative. Like you can see it, it's duplicating. And that's where the confusion is coming in, because obviously if you have the two in the UN model, if you have both of those possibilities, then the taxpayer has to decide, well, which one do they want? And then they can alter their behavior accordingly. But hopefully, according to the tax authority anyway, hopefully the taxpayer doesn't just wiggle away by not having a PE or a fixed base. Instead, it's going to kick over to Article 12A instead of into exemption land, which is what you have if you don't have Article 12A and your Article 12 royalty doesn't include services. Okay, I know this is a lot, but I wanted to look at a couple of our treaties. I'm wary of the time, but I think it's still worth just a couple of them. I'm not going to go too many. Okay. All right. People can always just turn the YouTube off if they get tired of thinking about tax treaties. But there's a sunset in Montreal off of my my terrace at home, and you can see just a little sunset in the background, which means I think the sun is setting on the idea that any of this is going to make sense. Okay. So here's Brazil 1984 treaty. Okay, you had us in your category 2, Sergio. And when I saw your slides, I thought, well, did I misread my own treaty? It's possible I did. So let's talk about this. Because here's what I see. I see in our treaty 2 rates, a 25% and a 15% rate. We see a gross amount of royalties arising from the use or the right to use trademarks getting subject to this 25%, and then everything else subject to 15%. So there's some special, I don't know what the deal is with trademarks, but for some reason, we really want a higher rate on those. I don't know why. And then here's what royalty means. It means, okay, look at the 3, the copyright, trademark. So that's the fee for use stuff. And then there's the equipment And there's the information for experience, but there's nothing about services, like what we said in our domestic law. So there's also a source rule and an ordering rule in paragraphs 4 and 5 of article, should be 13. I have 12 written there, but it's 13, sorry. No, it is 12, sorry. Let me reverse that. It's article 12. Paragraph 4 gives us a source rule and paragraph 5 gives us an ordering rule. Okay, and the source rule is just telling you that the source of a payment is the residence of the payer, but if there's a PE, then it's the source, and it's related to the PE, then the source is the PE. That's fine. That's source-based. And then you have an ordering rule that tells you that if the payment is connected to the PE of a business, go to Article 7, and there's nothing about independent personal services, like not a word, even though we have an IPS provision. However, the IPS provision in the Canada-Brazil Treaty has a fixed base, has a permanent establishment threshold. So I'm not sure what's going on. Like, did they just forget that they had this in there, or like, did they not understand the structure of this, or what's happening here? I don't know. You have a thought on that?
No, you missed the protocol because.
Well, I couldn't find the protocol. I cannot find the protocol on any of Canada's official pages. Exactly. So when you said it's in the protocol, I said, where's my protocol? And that does not surprise me if it's not on Canada's website. It's not there. All we have is the 1984 treaty.
You see, that's interesting because it is in the protocol. We have the standard provision in the protocol of the treaty establishing that technical services and technical assistance services will be treated as royalties.
Okay.
And it's funny you mentioned that you don't have it in the
I can't find it anywhere
website.
Yeah,
because
it's not there.
There is this. I don't know, Canada is kind of a dream country where you don't have extreme right and in power and things like that. But I think that in Brazil, there is a overwhelming criticism on ourselves, like we do everything wrong. And a situation like that would be, you look, this is Brazil's tax administration that wants, the taxpayers to be in the dark and don't give them the information, etc. And you see, you have this situation with the Canada tax administration, but you can trust me, it's there.
Yeah, no, I believe you. So this was going to be my question for you. So I want to know when the protocol happened and where is it and why isn't it in my official law on the Government of Canada website that gives all the treaties and all the protocols. There's nothing, no exchange of notes, nothing about any changes. So we should investigate this. But so my point in putting it on the slide, though, is not to say it doesn't exist. I believe you that it exists, and I am sure it says what you say, but this is 1984. So in 1984, this treaty does not match what I would have expected from our desire to tax technical services and your desire to tax technical services until I heard what you said about 1990s being when this issue became real.
But our protocol, I guess, was signed together with the treaty. So because that's it's not in some cases, we have these new protocols, but in that particular case, here in Brazil's tax administration website, it's the same text. So you have the full text of the treaty, and then the protocol already starts. It's already there. It was signed by the same people. So it's funny that you wouldn't have it.
Look, it wouldn't be the first time that I found something and didn't find the whole thing, right? So let's just see here.
And since we interrupted a little bit, I would just like to point out that you've mentioned this ICS, what you're calling? This definition of industrial, commercial, and scientific.
Yeah.
This is so intriguing because we have the same thing here because of the other provision in Article 12.3, which establishes that payments for the right to use industrial, scientific, and commercial equipment are royalties. We have that in all of our treaties except the treaty with Finland.
Oh,
and
interesting.
And it always intrigued me because it's very difficult. Again, it's an expression that's not defined in the treaty.
Right.
It's very hard to define. So what are commercial?
I don't know. What is that?
Equipment at this point at this stage of the game, because industrial and scientific, you more or less, but a few years ago, and sorry for this interruption. A few years ago.
It's not an interruption. That's why I put it on the screen. I said, I need to make sure I figure this out. Actually, I just found the protocol. You're right. It's at the end of the treaty, and it says.
Did you find it?
Yeah, I just found it. It says it's understood that the expression information for experience includes income derived from rendering technical assistance and technical services. So they are interpreting the information experience as opposed to using the domestic services provision.
And among that type, when I presented that block of treaties, I said that there are differences among them. This wording is not the most common. It is in the treaty with Canada. It is in the treaty with Spain. But in that group, most of the treaties just say something like, the parties agree that fees for technical services and technical assistance services are in the definition of royalties.
In the definition of royalties.
Without this comparison with, the commercial and industrial and scientific knowledge. This is the exception. The treaty with Canada is the exception.
And why would we do that?
I don't know. There was this guy called Francisco Dornelles. He was a congressman and a senator, and he was the vice governor of Rio de Janeiro. He must be very old nowadays. I don't know, in his 90s. If he's still alive, I guess he's still alive. But he was in charge of negotiating the first Brazilian treaties, and he represented Brazil in the negotiations for the UN model, the first UN model. And that guy was, the mastermind behind this kickoff of Brazil's treaty policies.
Yeah.
And for a long time, I wanted to talk to him to see if I find answers.
Yeah.
To some pieces of the puzzle of why we did some things, and I never could. And maybe now it's too late. He's still alive, but he's too old. I don't know if he's still. He disappeared from public life. And I don't know if, going back to the 1970s, 1980s to discuss is one of his top priorities nowadays. Probably not. But maybe this is something that I should do. Try at least to find if,
Well, I'm curious about it because so word to tip to students of international tax, the protocol for the treaty you're talking about is actually just stuck to the end of the treaty. I just didn't know it was there, so I didn't go all the way to the end to find it. So word to the wise, it's there. It's there on the Canadian website. It's just at the end. So I'm offended by a protocol that changes the treaty at the same time as a treaty is signed, because just change the treaty. I hate it when they do this. But it is there. But there's a decision here that I don't understand, right? So the UN model has the exact same language. Information concerning experience. And the source of the debate appears to have been whether you should interpret that to mean, what did the language you used for transfer of technology or knowledge transfer. And we seem to be using a lot of words in different ways to say the same thing, all to try to explain why some things connected to IP are going to be taxed where the payment is made at source, whether you have a threshold or not, whether you meet a threshold or not. So we don't want to have a threshold. But like, why not just say, like you're saying, why not just say that it's part of royalties? That's what we do in our domestic law. It's royalties. You know, why go into these levels of complexity? And I don't know the answer to that. But when I looked at the Brazil treaty, I said, okay, that's interesting because, well, let me just do one more comparison. So that's Brazil. What about India? This is 1996. And look at their Article 12 in this treaty says specifically includes the language, royalties and fees for included services. Well, I don't like this language because of what we were just talking about. If no, information for experience is a fee for a service which is included in the royalty definition, then why would you need to say it's about royalties and fees for included services as if it's a second category?
Alison, the slide is not there.
Oh, no, there's nothing on it, just the title.
Okay.
I'm getting there. 1 second. So just look at the title, Article 12, okay. Royalties and fees for included services. We should stop soon because we're getting tired from being on YouTube for too long. Again, with 2 rates, but this time the 2 rates are a higher rate for payment to use or right to use the first category, right? The literary, artistic, scientific work, patents, trademarks, etc., and information for experience. Okay, check it out, Sergio. 20% if you pay for the right to use or the right to use or use of information for experience, which in the Brazil treaty means technical services. And here, but look at the payment for right to use or right to use industrial, commercial, or scientific equipment gets a lower rate. So is your fee for under 3A or is it under 3B? It's a 10 percentage point difference, right? So then here you get this fee for included services. Okay, so remember the article is called Royalties and Fees for Included Services. And now we're going to define fees for included services to include payments for rendering technical or consultancy services if they have to be ancillary and subsidiary to the application or enjoyment of the right, property, or information for which a royalty is received. And they have to make available technical knowledge, experience, skill, look at that word, know-how, or processes, and develop and transfer a technical plan or design. So already I'm getting confused. Like, what? There's so many words here. And then there's an exception, exclusion, which you can see. I think you see this sometimes in the UN. Maybe I've seen this in the UN. I can't remember where I saw this, but you see these exclusions for shipping, for education, for personal use, and then this exclusion for professional services of an employee, which kicks out the dependent personal services article.
But Alison, it looks like Alberto negotiated this provision because isn't it similar to what he was saying?
Exactly. It looks like yes. Maybe Alberto.
I didn't know that Professor Xavier was the negotiator for Indian or Canadian treaty.
I don't know who negotiated, but I can tell you I struggle with this provision because I don't know what's a royalty and what's a fee for included service. I don't know if we're defining fees for included services as somehow not a royalty or it is a royalty. And then when you say fees for included services include these other services, if they are these things, and then you use the word royalty in the definition of that, to me, it's very difficult to parse this language and understand it. And then, of course, you have the ordering rule and the source rule. You have the ordering rule if you're connected to, so you kick it out to Article 7 or 14. And then you have the source rule again saying, the source is the residence of the payer, but if it's connected to a PE, then it's the residence of the PE. I find this extremely vexing which is why Sergio, somebody really should write a book.
No, and yeah, no, that's us. But I look at this, and we need to find someone from India to discuss this
to explain this to us. Yes,
because I look at this and I see India's fingerprints on it, because if you remember my slide, India is also in the same group.
Yeah.
But the wording of their protocol is different from all the others. It's broader. It refers to consultancy services, managerial support services. It's much broader, but it's not like this one you have here. So when Professor Xavier was negotiating treaties for them, he negotiated a treaty with Canada, but not the treaty with Brazil. But maybe it was Brazil's reaction to what they wanted, because if you look at our treaty with India, it's probably out of that whole group, the broader provision regarding the taxation of services.
Yeah.
It's much broader than the others.
Yeah.
But it's not Xavier like just like this one you're showing.
Yeah. So I think, so for me, when I read Brazil, now that I read Brazil with the amendment to the definition, including technical services in the knowledge, information for experience language, that actually slots it into place a little bit better. It makes a little bit more sense. But then the India provision seems to be the extreme of like most wordy, most categories, most overlapping categories, and really hard to untangle. Like, how does that actually work in practice? I don't actually know. So I think we should probably stop. We've been going on for quite some time, but I think this is just the beginning. This is why I said, like,
I spoke for too long.
No, you did it because, look, when you do these live streams, you know, they're not like a conventional conference where everybody gets a specific time. It's more of a conversation, more of a discussion. And for me, this is you telling that story of the progression is really key to understanding, you know, how are we supposed to interpret the language? And I think now that I've heard yours, I'll go back again and rethink how this all works together. But I think we need somebody, we need an expert, a treaty expert who remembers the history in all of our jurisdictions.
Look, there are consequences to what we are saying. For instance, if Brazil has tax-sparing provisions in many of its treaties, and Brazil's tax administration interpretation is that, for instance, if you're paying a law firm or an engineering service, whatever, these are all technical services. Mm-hmm. That means that the other country should acknowledge that payment as a royalty payment and apply the tax-sparing provision.
Yeah.
And grant a higher tax credit. The question is, would they? The discussion I was having with the Netherlands, because we had a charter agreement with a Dutch entity, and it was a bareboat charter. And when it was a bareboat charter, Dutch authorities applied Article 12 because, according to them, it was industrial, commercial, scientific equipment. Then it was a royalty. But the company changed the contract, and it was now a time charter, which includes crew and so. And then, according to Dutch authorities, it's no longer the rental of an equipment; it's a service. It's a technical service. And the position from the Dutch lawyer was, yeah, no, you're no longer entitled to tax sparing, because now you're outside Article 12. And I said, yeah, you know, from a Brazilian perspective, if you're telling me that this is a technical service, the official Brazilian approach to this is still a royalty, and tax sparing would still apply.
Yeah.
And then they came back and said, yeah, we don't know if the Dutch authorities would agree with this because we have no experience in applying the protocol.
Wow.
With Brazil, and what the tax authorities would think of this argument that a time charter is a technical service. And I think that's because it's not only, and there's another thing, I had a slide about this that I excluded, and I was right to do that because there's another discussion here whether or not this falls under the so-called new approach. Is this a matter of interpretation or is this a matter of qualification?
Exactly.
And if this is a matter of qualification, does any of the countries have a prevailing power to qualify this income in the treaty? So if Brazil says that this is a technical service, is the other country bound by Brazil's qualification and is required to, allow the use of the taxpaying provision? There are layers of complexity here. And what amazes me is that we have had this topic on the table maybe longer than any other country in the world, because we've been discussing this seriously since 1998 at least. So we've been
I mean, at least 1984, because that's when our treaty dates to.
But as I said, it wasn't an issue here until 1998, until Professor Xavier realized that there was a good argument there to say that there was no withholding in Brazil. So it was the late 1990s when we started discussing this. This was my first article, my second or third, but for purposes of emphasis, I'll say that
it's still not solved. You didn't solve it. What?
Yeah, I published about this back in 2000.
Wow.
I was 22, 23 years old, and it was my first. I look at this and say, certainly my first paper on international tax issue. And we're still here debating, and we haven't scratched the surface.
No, barely.
It's many of the people that deal with this, they're just focused on winning a case. They're not focused on actually understanding the topics and everything. So this was long, almost 2 hours. There's something I want to show you.
Okay.
Look, I hope you don't have copyrights on this. Look at this.
That's awesome.
I wasn't the one. I wasn't the one who did it. A student of mine was watching our previous conversation, and he said, I did this for me and a couple of friends.
Nice.
And he sent me one.
Good.
So I hope we're not infringing.
I love to see it. I will send it to anybody who wants the design. I will send it to you. You can use my design or recreate.
You do this, but I got this as a Christmas present.
I love to see it.
This master's candidate, and it looks pretty good.
It looks great.
Yeah, at least on the screen. Look.
We can hold them up together.
Yeah. Yours is better than mine.
Well, mine has the red handle, is a little bit bigger.
It looks bigger.
But hey,
but now I have one. Yeah.
We got to spread the love. Actually, I got to tell you, on my Redbubble page, you can find that I made one in Portuguese.
Oh yeah,
I did. Yeah, I'll send you the link. You can put it in the YouTube if anybody makes it to the end.
Yeah, I don't know. I don't know if there are that many people. Yeah, I need a text hug. I really don't think so. Yeah, but I think, maybe after this.
Maybe after this. Listen,
that probably it's just us now because it's lunchtime here. No one there.
There's people watching. Yeah, I just noticed.
Yeah, we have this conversation there. We can spread the word and send the link, and then the magic will happen.
I think that I love that we had this conversation because, one, I just need to understand this area a little bit more, inspect the treaties a little bit more, inspect the language a little bit more, and try to get an understanding of the insertion point, right? Like you can put it at many different places and you can stack them different ways, but do they get to the same place? I don't actually know. That's not usually how law works, right? Like it's not usually this much chaos. So I think we got a great project on our hands. I think we got a good start here today, and we just have to continue. We'll just get some more experts and do another round.
Yeah, that's it. So it was great meeting you again. Yeah,
always fun to see you.
Yeah, and we have to find someone to publish whatever we do as a result of this.
Yep.
Let's see if the Google wants us back.
We'll see what happens. Yep.
Yeah.
All right.
Okay. So thank you very much.
Well, thank you. And thanks for everybody who watched or listened all the way to the end. Like, bravo. You are true tax nerds. And I'm sure we'll come back and we'll do some more soon.
Yeah. Okay. So bye-bye.
Bye.